Campus Raub.
Hi, my name is AMIRA YUSNI and I will explain about the introduction to collective bargaining in Malaysia. So, collective bargaining can be defined as the process through which employees, through their unions, negotiate contracts with their employers to determine their working conditions such as benefits, working hours, leave, employment health and safety requirements. Collective bargaining is the most effective technique to build a pleasant relationship between employers and employees. Collective bargaining is the most effective technique to build a pleasant relationship between employees and employees. So, a country industrial relations system must include a legal structure that permits parties to bargain collectively with the purpose of achieving a collective bargaining agreement in order to fulfill these goals. At the same time, worker representatives meet with employees representatives to discuss employment terms and conditions. During the early years of the industrial revolutions, there was sign that collective bargaining would play a significant role in the industrial relations. The Industrial Relations Act of 1976, which includes a collective bargaining mechanism, has been enacted in Malaysia. Industrial Relations Act of 1967 governs communication between employees and employees, as well as their trade unions, as well as the prevention and settlements of any conflicts or difficulties that may emerge as a result of their relationships, as well as the handling of trade dispute in general.
Unfair labour is one of the factors that can lead to the failure of collective bargaining in Malaysia. Unfair labour is an action where employer or trade unions make an unfair treatment towards an employee. Termination of contract is one of the examples of unfair labour. According to the Malaysian law, employers must have good reason and excuse before terminating employees. There must be a genuine and valid reason beyond the termination. If any employee believes that they were terminated unfairly, they can file a written complaint. If an unfair dismissal claim is successful, the industrial court may order either reinstatement and back pay or back pay and compensation in the place of reinstatement. For example, in the case of Norzaifi Khalid Nordin vs Murphy Sarawak Oil in 2017, the industrial court had awarded the former employer of the company about RM1.2 million, which is back pay and compensation, after it ruled that he was unfairly terminated. That's all for me. I'll pass to the next presenter.
Next example of unfair labour practice is about payment wage. Part 3 of the Employment Act 1955 covers about wage payment. According to Section 18(1), the wage period clause in a contract of service must be 1 month or less. Due to this, Section 18(2) states that if no wage term is specified in service agreement, the wage period is presumed to be 1 month. If the contract of service does not specify a wage period, the period for payment of wage is automatically be 1 month. Furthermore, Section 19 states that an employer must pay each employee's wage less lawful deduction within 7 days after wage payment period. If the Director General is convinced that payment will not be made within this period, he may grant the employer an extension of up to a few days. This rule requires employers to pay employees' wage no later than 7 days after their last pay date. However, not everyone avoids making mistake. It refers to a case where an employer at a Goodyear Malaysia tire factory in Shah Alam reportedly failed to pay foreign workers' salary. A number of foreign workers at a tire factory had complained of unfair treatment and poor salaries. Approximately 250 foreign workers filed 5 complaints. The employer has been found guilty by the employee-employer collective bargaining agreement. In addition to not paying wage, Goodyear employees threatened foreign workers and did not provide shift allowance or annual bonuses. Rejection of access to passport and illegal overtime work were also accused. Obviously, unfair labour practice in the factory include racial discrimination and wage failure.
In Malaysia, collective bargaining is the most effective means of achieving a fair relationships between employers and employees. It is also an effective forum for negotiating employment terms and conditions. One of the reasons wherefore collective bargaining was failed in Malaysia was because of economic situations. For example, in 2020, the economic situation in Malaysia was falling apart because of the COVID-19 pandemic, and the impact to the country were like mass redundancies, retrenchments, and dismissal of employees in all sectors of employment. Economic situation can be happen between trade union and employers, like when the trade union cannot get opportunity or chance to increase their salary based on their long term of working in organizations. For example, as in the case of Malaysia Airlines System Berhad, Ismail Nasruddin bin Abdul Wahab, where the respondent was fired because of the economic situation happening during of the pandemic COVID-19, and he also was getting fired without getting any notice. It was shown that the organization was affected by economic situation, which is they cannot pay wages for the employee that causes the collective bargaining fail in the first place.
Trade union crisis between employers, including paying employee wages late. Employers must pay monthly wages on the 7th day of the next month or sooner, according to the Employment Act of 1955. However, in Malaysia, the Act only applies to a few specific employment classifications. Employees with a monthly income of less than 2,000 ringgit are the first to come to mind. Employees who work in manual labour, irrespective of their monthly income, are the second characteristic. Domestic servants are the third characteristic. Last but not least, various groups of employees covered by the Employment Act 1955 first schedule. For instance, in the case of Gataman Teva Laman Ryan versus JSAE Resources Negerian Berhad, the Industrial Court granted 43,000 ringgit in unpaid pay to a probationer who worked for transportation services provided for 2 months after the employer defaulted his salary. On September 14, 2019, he resigned from the company. The claimant had updated with Mahendran on September 20, 2019 regarding his underpaid August salary, but his boss threatened him to report the incident. Mahendran went to the claimant's house the next day, where Gautaman was shoved and physically assaulted in the chest by the managing director. The violation and attack were charged with a crime, and yet no action is being taken. Mahendran's insolence, she added, was stunning, to put it lightly, and that further demonstrated that the corporation had no regard for its employees and their legal rights.
The factual evidence presented in this study indicates that trade unions at all levels, as well as employers' organizations, individual employers, and management are all involved in the delayed return to the disaster. National governments, ministries, and municipal governments are all engaged, in some circumstances either directly as participants in agreement or indirectly through public policy that determines the sorts of agreement that unions and employers might reach. Short-term employment arrangements, which are adopted through collective bargaining, are the most apparent expressions of the latter. Industrial relations institutions in general and collective bargaining mechanisms in particular have played an important role in tackling the crisis issues in this area. This isn't to argue that negotiated answers have always been calm and consensual. In many circumstances, a disagreement and conflict are necessary parts of the process. The goal of the negotiation process is to come up with solutions that balance the interests of both employers and employees.